Does your license need saving? Do the wise thing. Call Wiseman Lawyers. Does your license need saving? Do the wise thing. Call Wiseman Lawyers. Don't face that court alone. Let the Wiseman team get you back on the road. Does your license need saving? Do the wise thing. Call the Wiseman team at Wiseman Lawyers.
Alright, today I'm at Toowoomba Magistrates Court. Client was charged with repeat drug driving. There was 2 drugs found in their system, cannabis and methamphetamine, and it was a repeat, as I said, drug driving offence. There's 2 types of drug driving. The more serious is what's called drive under the influence of a drug, meaning you've consumed it, you're still high, and you're still under the influence of that drug. The lesser charge is what's called drive whilst relevant drug present, meaning you've had it at some point, the effects have worn off, but there's still traces of it in your system. My client was charged with the lesser of the 2, but there was traces of 2 different drugs found in his system, cannabis and methamphetamine ice. He had a previous, within the last 5 years, late last year, of the same charge of drive whilst relevant drug present. Basically, if you've got a previous in the last 5 years, the penalty range is increased. So if it's a first offence of relevant drug present, or there's no history in the last 5 years, worst case is a 9-month loss of licence, mandatory minimum is 1 month. But if you've got previous, well, it depends on how much previous as to how much it goes up. But if you've got 1 previous, which my client does have, the maximum bumps up to 18 months, mandatory minimum becomes 3 months. And because you've got previous in the last 5 years, and as a consequence of that you've lost your licence in the last 5 years, you cannot get a drug driving work licence. With a drug driving work licence, basically if you get charged with drive whilst relevant drug present and you haven't lost your licence in the last 5 years and you're the holder of an open Queensland licence and you satisfy a number of other prerequisites, you can apply for a drug driving work licence. And what that is basically you still get a disqualification, but the magistrate can, if you properly apply and argue the application correctly, make an order overlapping the disqualification, allowing you to continue driving for work purposes only. So you're disqualified, but during the hours of, for example, 6 a.m. to 6 p.m. Monday to Friday, you can continue driving for work purposes only. But my client was not eligible to apply today because of that previous. So worst case today was an 18-month disqualification, mandatory minimum 3 months, no work licence eligibility. So my job was one of getting it down as low as possible, and as I've already stressed, the lowest possible disqualification was 3 months. With regards to preparing, I've got my client to complete a reformatory course. We get all of our clients to do it. It can be done online. I asked him to get some character references based on a template we would provide each of our clients, guiding the referee as to who it needs to be addressed to and the key points that need to be addressed. There's no point going to court with a reference addressed to whom it may concern and talking about how fantastic the person is, yet it makes no reference to the fact that they're aware of the charge, or at the very least that they're aware that it's being tendered in court. You might as well hand up a shopping list. The magistrate will literally push it to the side if it does not clearly indicate that it's been written for that purpose. I got instructions prior to today, prepared my submissions prior to today, drove up from Brisbane this morning, met the client in a conference room. I ran through the procedure, you know, who stands where, what he can expect the prosecutor to say. I went through my submissions. Basically, you know, I'm trying to convince the magistrate that he's a good person, notwithstanding, discuss the underlying issues that have led to this ongoing offending, etc. Spoke about what he learnt at the course and all the rest of it. I spoke on my feet for a moderate amount of time, not a lengthy period. The short version is, though, that I was able to persuade the magistrate to give the mandatory minimum 3 months. So 3 month disqualification, modest fine. Client's very happy, given it was literally the best possible outcome. He just obviously doesn't drive for the next 3 months, renews his licence at the end of it, and then he's back on the road as per normal in 3 months' time. So, as I said, worst case 18 months, mandatory minimum 3 months. I got him 3 months and a modest fine. He's very happy. I'm Andrew Wiseman at Toowoomba Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the Wiseman team get you back on the road.